Welcome to James Madison's Montpelier. I'm Ryan Nobles of NBC 12 in Richmond, and we're continuing our discussion on the Bill of Rights with Peter Irons, who's the Political Science Professor Emeritus from UC San Diego and a graduate of Harvard Law, Tim Longo, the Chief of Police in Charlottesville and an attorney himself, and Stuart Harris, who hosts a weekly public radio show called Your Weekly Constitutional and is on the faculty at Appalachian Law School. How has the press been impacted, and how has the interaction between government and the press been impacted by the First Amendment and that clause of the freedom of speech?
It's always been a contentious relationship, but the courts in general have been very protective of press rights, going back to the Pentagon Papers case in the 1970s, and even more recently, the allowing reporters to withhold their sources, their confidential sources. So that, you know, there's this constant tension. It's always been there, and it will probably always continue.
Stuart, when the Founding Fathers drew up this document, do you think they ever anticipated what the press would be like today? A vigorous press, a press that works very hard to hold their public officials accountable.
I have great respect for the founders, but they were not mind readers, and they couldn't predict the future in every respect. And they couldn't have imagined WikiLeaks. They couldn't have imagined nuclear weapons. And I mention those two particular things because most people have heard about WikiLeaks, and they've heard about people getting confidential cables from our State Department and revealing lots and lots of things that maybe a responsible journalist shouldn't have. You know, I'm not saying they went too far, but you know, arguably they did. An even better example is something called the Progressive case from 1979, where a newspaper or news magazine called The Progressive actually sent out a freelance reporter to find the quote-unquote secret of the hydrogen bomb. And using only public sources, he found a lot of stuff that might help an unfriendly nation or maybe even a terrorist group to develop nuclear weapons. He published it. So I'm a big fan of the First Amendment. I'm a big fan of the press, but since you're a member of the press, I'll take this opportunity to say that with great freedom comes great responsibility. I think I'm quoting Spider-Man there. But it's really true. I mean, it's really true. You guys, I want you to be out there, and I want you to be aggressive, and I want you to question government, and more power to you. But when you come across something like, you know, hydrogen bomb plans, maybe best to think about it before you publish.
Well, I think this is an excellent time to have this conversation, because I would always err on the side of the more public, the better. And a good example of this would be there's this rise in the use of drones by the military. And it seems like a good idea when they're being used in Pakistan and some other countries. But Peter, they're starting to be used maybe in our own backyards. Is this an example of where a vigorous press, even perhaps where we get into that area of responsibility versus what the public has a right to know, that it may be better for the press to have some leeway in these areas?
Well, I think that the drone example that you cited, Ryan, is very good, because the modern technology of how privacy can be invaded is just expanding rapidly. I mean, literally, with technology, the law enforcement and the government can look into your bedrooms. They can look in, I mean, infrared. They can find heat rising from people who are growing marijuana, for example. And the press, it seems to me, has an absolute right to publish anything relevant to this so that the public can know what's actually going on, and in fact react to it if they think the government is overreaching to try to persuade Congress to cut back on these invasions of privacy. But the press itself, I think, has a right. Stuart mentioned the Progressive case. Well, the courts in that case ruled that the journalist in question could publish that material, even though it might enable some foreign power or unfriendly entity to get information it might otherwise have. But keep in mind that all of the material in that case came from public records. He didn't steal any secrets.
Well, this is a great time to bring the chief in, because obviously as a member of the press, I'd like to know everything that you guys are
bet you
working
would.
on. and there's certainly a lot of things you don't want me to see. And you're dealing with this, of course, you had a very high-profile national case with
Sure.
a lacrosse player that was killed. And I know that my news station and many other news stations sought to seek access to every part of your investigation. As somebody that understands the First Amendment, how do you deal with that balance every single day, and when is it appropriate? And is there a responsibility for journalists to know where that line should be drawn? If I come across a piece of information that I shouldn't, where should that line be drawn?
Well, you know, I think you spoke perfectly to the issue of balance. We balance every day the rule of law with the need to perform a legitimate governmental function. In my case, police work. I think anytime you deal with issues of prior restraint, it's going to be looked upon by the court with tremendous amount of scrutiny. And the question at the end of the day is that information or release of that information, in the case of the Pentagon Papers, would it be irreparable harm to this country and our national security? In the example that you just gave, how's it going to affect the investigation? But more importantly, the right to the fair trial that defendant's entitled to. Bottom line is, the more information you leak out to the prospective jury pool in a community could have an adverse effect on that criminal defendant's right to a fair trial. To have people that will come into that courtroom with no prejudice, having not prejudged guilt or innocence, but come with an open mind. And when you've given them facts in advance of trial, it's very difficult to know for sure. No matter what the process is with regard to jury selection, it's really, really difficult to know for sure whether that person has been exposed to information that has affected their outlook on this case.
And it seems, Stuart, that in most cases, the courts have defended the rights of journalists to print information, but sometimes it's the people that release that information that get into trouble. I mean, the White House is dealing with this right now with a pretty high-profile leak case. Yeah. So it's okay to print it, but it might not necessarily be okay to leak the information.
Yeah, I think that was the distinction that Peter was bringing up before. You know, if you're a government official and you leak classified information, well, technically you're probably committing a felony. I believe it's the Espionage Act of 1917 is one of the federal statutes that criminalizes that. But what if the president kind of says, hey, go ahead and let them know about this, you know, because that'll help us politically. Now, I'm not saying that's what happened currently with President Obama. I'm not taking sides, but that's always a question, isn't it? You know, are they selectively enforcing the law and allowing themselves to leak information that helps them, and then they're going to prosecute anybody else who does?
Yeah, but I think there are differences between the kinds of leaks you're talking about, Stuart. But then there are the documents that are actually stolen from, literally, the government and released that may be quite dangerous to national security or to the safety of individuals. For example, if anybody released a list of the people who were on the drone kill list, for example, to alert them that they are targets, would the press be liable for publishing that kind of information? And it's a difficult question, and a lot of journalists, and I'm sure you know this, think very hard about whether they should sit on a story and wait until there's an appropriate time for releasing it. This has a lot to do with criminal investigations, for example. Who is a suspect? Who is a person of interest? What kind of evidence has been uncovered that shouldn't be released to the public because it might prejudice a jury pool?
All right, very good. Thank you, gentlemen.